All right, well, why don't we get started and we can continue to register people as they come in. I want to welcome everyone to our series of town halls at the Jacksonville Urban League Center for Advocacy and Social Justice. Tonight we'll be talking about pretrial detention and bail reform. We have an excellent group of speakers tonight, and this is an issue that has been so silent so long that there's just not enough people aware of the need to focus on this issue and the fact that it can cause disruption in people's lives and their families because they can't afford bail or their other ways of detention that cause difficulty for individuals. I think we entitled the first phrase, Presumed Innocent. If you end up in jail for an alleged crime and you can't get out because you can't afford it, it does seem to mean someone's making a decision that you are guilty without a trial. So with that, we'll get started. And before we do that, I want to thank a number of people, all of the team at the Urban League for the support the center gets and these activities. Our interns, several of which are here, and we'll introduce them as we go through. One of our funding groups is the National Football League. Through the National Urban League has provided funding for criminal justice reform, and this particular town hall is in that series. So I want to thank them and their concern for seeing change. And I also wanted to thank our speakers who will introduce themselves shortly. And to start off, I will turn it over to Vincent Lopez, an intern of ours from the Florida Coastal School of Law. We're grateful for the efforts that you've made, Vince, to put this together, and we're looking forward to hearing from you and the speakers. So please take it away.
Awesome. Thank you so much, Mr. Stone. Okay. As he said, my name is Vincent Lopez. I'm a third-year law student at Florida Coastal School of Law. Criminal justice reform has kind of been a passion of mine, and one of the reasons actually why I went into law school. Bail reform in Florida here specifically has been a subject of scrutiny as of late, and there has been some leeway and or some headway made on this issue, but it's still a problem. Our jails are still filled with a lot of people who haven't been sentenced or pled guilty to anything. So with that, I just wanted to get started and give anybody a little bit of backdrop of what bail is. So 3 out of 5 people in U.S. jails today have not been convicted of a crime. So that's about 500,000 people sitting in jails every single day that haven't been convicted of a crime. The cash bail system is basically instituted over the greater part of our country. There are a few municipalities who have gone off the cash bail system, but basically the cash bail system is where the court determines an amount of money that a person has to pay in order to secure their release from detention. And so that's without any kind of trial or anything. So I want to go ahead and quote some statistics from some of the institutes where our guests are from. So this statistic is from the Vera Institute. 433%, the increase in the use of pretrial detention between 1970 and 2015. That's a lot. That comes from the Vera Institute. Next little tidbit I wanted to give comes from the James Madison Institute, which recently did a poll concerning bail reform, and they found that the majority of Florida voters are in favor of bail reform. So this is also a subject that has political traction. So I think that's important to consider as well. Just moving right along, I don't want to take up too much time. About 14 billion nationally goes into pretrial detention every year, and that's from the Pretrial Justice Institute. So this is an issue with a lot of money and a lot of interest. And with that, I'm going to go ahead and get into the panel. Our first speaker is going to be Will Snowden. He is the director of the Vera Institute New Orleans office. And I will go ahead and let him do a little self-introduction before he talks. Our next speaker is going to be Sal Nuzzo. And Sal is with the James Madison Institute. He's the Vice President of Policy and Director of the Center for Economic Prosperity. And our last speaker is going to be Ruth Ann Hepler, who is a criminal defense attorney here in Jacksonville. And she's got over 30 years of experience doing this and a lot of knowledge about bail reform here locally and the efforts to get that done here also in the state as well. So moving right along, I'm going to go ahead and pass this off to Will Snowden, and he can let us know what the Vera Institute has been working on concerning bail reform and how to get the needle moving in that area. Mr. Snowden, whenever you're ready.
Appreciate it. Money bail doesn't keep us safe. And I start with that because we have this false notion and understanding that it does. It's important to know that we keep people detained when they are presumed innocent and release them after they've been adjudicated guilty in many instances. And I start with this notion that money bail doesn't keep us safe because we have, at least in New Orleans, 30% of people in jail right now are there simply because they can't afford their bail amount. I do work with the Vera Institute of Justice. I'm the director of the New Orleans office. Vera is a national justice reform nonprofit. We started in New York in 1961 with a specific focus on bail reform, and we have since evolved and advanced to having conversations about reforming the criminal legal system in almost every avenue that you could imagine. Our work in New Orleans started in 2006. We were invited by then Councilmember James Carter to come and be involved in the conversations about how to change the criminal legal system after Hurricane Katrina. Before the storm, we had an average monthly jail population of about 6,500 people. Now we're averaging about 1,000 people per month. So it's a huge reduction, a huge testament that this size of the city does not need that size of a jail. And one of the most influential reforms that changed that needle in terms of reducing our jail population has been conversation about pretrial detention, has been looking at what types of pretrial services need to be provided, but also trying to understand what role bail should play in pretrial detention. Many of us are familiar with money bail. I want to introduce you to this term that we use at the Vera Institute of Justice called money injustice. And when we use the term money injustice, what we're talking about is the extraction of wealth from communities, both on the front end of a case, which is typically money bail, and then on the tail end of a case in terms of conviction, fines, and fees. And so we use the term money injustice to represent the extraction of wealth from poor and vulnerable communities, particularly here in New Orleans, but it's an element that happens around the country. Many of us are familiar with the way bail works, and I just want to share a couple of terms that's important to understand. When a bail gets set, you have a premium, and essentially the premium is what an individual will pay to a bail bondsman if you're using a commercial surety. So for example, if a judge sets bail at $10,000 in New Orleans, the premium is 12%. So my parents or my friends or my family would go pay a bondsman $1,200 and I would be released. Now it's important to know that the bail bondsman won't go and actually post any money. They'll sign a promissory note essentially saying that they will be on the hook if Will doesn't show up for their court case, if I don't show up for my court case. And the idea behind bail is that my family puts up an amount of money which incentivizes me to come back so that my family come to court so my family would get that money back. But the way that the money bail system has been commercialized, that money never gets returned. So I could go to trial and be found not guilty, and my parents won't get that $1,200 back. I could go to trial and be found guilty, money doesn't get returned. The case could be dismissed by the prosecutor and the money would not be returned. And I named that because it's important to know that the original intent behind putting up this collateral was to incentivize people to continue to go to court. But with that incentive being removed with the commercialization of money bail, we really have to question, what is the purpose of money bail? What is the purpose of using money as the actual instrument to decide who gets released from jail and who doesn't? And that gets to my point, that money bail does not keep us safe. I strongly believe that the keys to the jail should not be the coins in your pocket. And in Louisiana and in New Orleans, what we've seen is that if you pose a threat to our community and you have a ton of money, you can pay your bail and get out. And putting up that money does absolutely nothing to mitigate the potential threat you might pose to the community. But let's say you don't pose a threat to the community and you don't have money, what ends up happening is that you actually stay in jail. And just thinking about ways in which we want to consider promoting community safety, you should not be detained simply because you're poor, and that's the system that we currently have on a frequent basis. In New Orleans, I just want to just kind of lay out for you what the process is. If you get arrested, you will be brought in front of a judge for what's called a first appearance. They'll set the bail. The district attorney has 60 days to decide whether or not they're going to accept charges. That's for a felony case. They have 45 days to decide if they're going to accept charges for misdemeanors. And we know what happens over those 60 days if you're just sitting in jail. After a week, you'll probably lose your job. After 2 weeks, and you're not at the corner to meet your kids getting off the bus, you might lose custody of your children. After that month, and you're not paying rent within 5 days, your landlord could, file for eviction notice. And we know that we have this system of detaining people before charges have even been accepted, and the collateral consequences that come from that pretrial detention. I shared this notion that we have a system that detains people when they're presumed innocent, but releases them after they've been adjudicated guilty, to really demonstrate how illogical the bail system is. We have this presumption of innocence, but when we use money to keep people in jail, we're really disregarding that presumption of innocence. And our current system, at least in Louisiana, does not establish a burden of proof on the prosecutor when deciding whether or not to detain somebody pre-trial. Many attorneys know the case involved, the Supreme Court case Salerno, where there's this quote. It says, and I'm probably not even gonna get it right, but essentially, pretrial detention should be the carefully limited exception, and liberty should be the norm, right? Really thinking that if we are going to be taking away someone's liberty, there should be a demonstration of why that liberty should be taken away. And it usually falls around the understanding that this person poses a threat to community safety, and that there will be no conditions that could be put in place to mitigate that potential harm. When we talk about bail reform, really what we're looking at is alternative ways to decide what pretrial detention should look like, and removing the role that money should play. In New Orleans, we've seen a lot of progress in our reform around our bail system. We've eliminated money bail for all municipal court charges, with the exception of 5. And we are now in active conversations with our district attorney candidates. We're going to have a new district attorney on December 5th, as well as new judicial candidates that will be sworn in January, on what it looks like to continue this conversation of bail reform, what it looks like to continue just brainstorming alternative ways that we can decide what pretrial detention should look like in the city of New Orleans. We have proposed a plan to eliminate money bail in the city of New Orleans. I'm going to share, I don't know if I can, well, I was going to share a report that Vera did, kind of laying out a blueprint that would outline how New Orleans can get away from a money bail system. If anybody would like to see it, if you just go to the Vera website and you type in "paid in full," that will pull up the report, and you can see the plan that we put forth to eliminate money bail. Again, you just go to the Vera website, it's vera.org. You type in "paid in full," and you'll see that report that we put forth as a plan to eliminate money bail in the city of New Orleans. Thank you so much.
And thank you so much, Will. I appreciate it. So honestly, so speaking on that note, when I think of money bail and the injustice, that's the first thing that comes to my mind is people who can't afford their bail. And then there's this trickle down effect that, they lose their job, they can't fulfill family obligations. And I think that's where it really hits home and really hurts the communities, especially low-income communities first. And speaking along the same lines of the money injustice, I wanted to bring these up to kind of just give some flavor, some color to it. This is a real world situation. So some of these are kind of tragic. This is a situation from New York City. Khalif Browder, accused of stealing a backpack in 2010, arrested. His bail was set at $3,000. His family couldn't afford it. He was 16 then. He spent 3 years in jail in New York City and Rikers Island, and he died by suicide in 2015 there after not coming home. In 2017, senior citizen from San Francisco, California, had his bail set at $350,000 for stealing a bottle of cologne and $5 from his neighbor. He remained in jail for more than 250 days before being convicted because he could not afford bail. And Randall McCreary, a mentally ill man in Atlanta, Georgia, arrested that same year for disorderly conduct. His bail was set at $500 and he couldn't afford that. McCreary languished in jail for over 2.5 months, over which time the government discontinued his disability support. That was reported by the New York Times. And that kind of brings me up to my next question here is, when we get right down to it, what is the affordability of bail? Is bail affordable? That's, it depends on what you do and, the crime, but for the majority of folks, is the average bail affordable? And the big myth I wanted to get at is most people might assume that, cash bail is affordable. One thing I wanted to take into consideration is that Florida courts have also assumed that they take into consideration is that your family and all of your friends' ability to pay as well as you. So that's a huge resource to draw upon. And like Mr. Snowden mentioned, the money and justice, when it ends up, further going further than just the person itself, and they haven't even been convicted. So moving right along, just speaking of the costs, we've got Mr. Sal Nuzzo, who I think can comment on some of the costs and the economic issues regarding cash bail, the affordability of it, how many folks are going to jail and what the costs are to the state, to taxpayers in general, because this is an issue that has both high social repercussions and it especially has budget repercussions, especially when it comes to taxpayers and how we run our judiciary. So with that, I'll go ahead and let Sal.
Vince, just before Sal gets started, I see that this is Dennis Stone, Center for Advocacy and Social Justice Director, and I see that Richard Danford has been able to join us.
Okay, sure.
And he was on a radio program and was able to break away. Richard, are you with us?
Mr. Danforth, you there?
Good evening. Can you hear me?
Yes,
sir.
Oh, great. I tell you, I just want to welcome all of our listeners to this evening's program. And I would love for you to see me. I'm in a place where I should not be seen. But this is a very important program in terms of bringing to light the difficulties that normal citizens have as it relates to bail, and it's somewhat perplexing because it varies from state to state, and it seems that certainly in Florida we're getting the blunt of all of the disparities, the situations that exist for many people, certainly of color and certainly those of low income. So I look forward to more information, and hopefully we can assist in moving the cheese on this, such that citizens will have more of an opportunity to prove their innocence without having to be burdened with the financial situations that perhaps the system is using to pay for their work. So there are a lot of issues involved in this, and I'm happy to be on, and we'll continue to stay on. So thank all of you, thank our participants for your expertise here in terms of working with us. So with that, Dennis, I'll be quiet and listen in. Thank you very much.
Well, thank you, President Danford, and thank you for all of your efforts to, as you say, move the cheese on so many of these issues for over a couple of decades now. You've been doing this in the community, and we appreciate it. So thank you. Vince?
Thank you very much. So moving right along, before Sal speaks, I wanted just to mention some places that have made complete bail reforms, such as Washington, New York City, and California. So a lot of those case studies are coming out and they have been successful. So there's a lot of different ways to attack this problem. And I think as Mr. Stone outlined, what I see coming out of this thing is, the social cost is what is the big injustice for me. And I think that's something that we can all agree on, no matter where we sit on the table. That's something that, shouldn't be, especially in this day and age. So there's lots of different ways to attack this, and maybe Mr. Nuzzo can give us some solutions and to enlighten us on what the James Madison Institute is doing to work on this issue.
Sure, and thank you all very much for inviting us to participate in this. It's a great event, it's a great forum, and something that we've taken as kind of a passion project of ours over the last several years. My name is Sal Nuzzo. I am on the policy team at the James Madison Institute in Tallahassee, Florida. If you have looked us up or are familiar with us, you would probably get the impression, and rightfully so, that we are a philosophically conservative organization. We focus on economic issues that face the Sunshine State. I spend a good chunk of my time in DC working with federal lawmakers, but in addition to that, probably about 70% of my time is working with lawmakers in Tallahassee, in the Capitol, in the State House and Senate. One of the things that I wanted to kind of give you a little bit of background on is why this issue would be of importance to an organization like ours that focuses on economics and that it largely is considered a conservative organization. Over the past 15 years, you've had a plethora of criminal justice policy reforms bubbling up in states that have turned the tide on the economies and the budgets of those states moving forward. It really started with the state of all places, Texas. About 15 years ago, a conservative lawmaker decided that he was tired of the Department of Corrections coming to him, telling him that they needed to put another $1 billion in their state budget to build another prison to incarcerate another 10,000 people or another 5,000 people. And so he finally decided there has to be a better way. He began an in-depth examination of the economics behind incarceration at all levels. And as a result, the state of Texas, a very conservative House and Senate in the state, began a series of reforms that addressed incarceration in their state. And over that time, they saved billions of dollars, and they closed several prisons across the state. At the same time of that reform, fast forwarding, the state of Texas has enjoyed a drastic reduction in the rate of crime. And the kind of causal impact of that was felt by a number of other states that said, oh, wow, we can reform our criminal justice policies, we can save our state money, we can better protect the public, and we could still enjoy the reductions in crime that are occurring across the country. And so what we had is kind of a series of coalitions that were built over the last several years that began to work in specific states to address these issues, with pretrial detention being one of the big ones. It hasn't been as successful as others, but this is kind of the thing that I wanted to bring about and talk with you about, is the fact that over these years, conservative and progressive organizations have come together and worked on the exact same policy goals, but have been able to achieve success in both red and blue states because they've been able to bring along their audiences and speak to them in the ways that they most are going to be persuaded. So, for example, in Florida, we had some success in working on juvenile justice reform. We did that by working in a coalition with the American Civil Liberties Union, with the Southern Poverty Law Center, with Human Rights Watch, along with the Charles Koch Institute, and a number of other organizations that brought to bear their perspectives. And so on the progressive side, you largely had folks approaching their audiences and talking about things like the disparities in place and the social language of how you approach kind of a reform and what its impact is going to be. On the conservative side, I would speak around the state and to groups like this and others, and I would talk to conservatives, and I would talk with them about the ability of the state to save money, to better protect its citizens, and to better steward tax dollars. And when you frame that argument for conservatives, they largely come along. And I'm glad you pointed out that poll, because when we conducted that poll, while we were pleasantly surprised, we were not shocked because we understood the economics behind it. Will had mentioned this concept that we've been trumpeting a lot, the idea of collateral consequences. And he talked about one aspect of it. And the aspect of it that we've approached with conservative audiences is that for every percentage point that you can reduce recidivism, and by that we mean folks that are not reoffending, or folks that are, whether it's they're getting they're not going to jail on a pretrial detention bond that they couldn't pay, or they're not going to prison because they're a nonviolent drug abuser that's being treated as a trafficker. If you can reduce recidivism by a percentage point, you save not just hundreds of millions of dollars, you save billions of dollars in long-term costs for things like the social services safety net, for greater employment, greater wage earnings. There is an economic argument that we've been able to bring to bear that has resulted in a number of states advancing the ball on positive reforms. And so kind of what I'd like to do just in the last couple of minutes that I'm going to speak is talk with you a little bit about what our policy goals at JMI are on top of the pretrial diversion reform. On the juvenile side, for folks that are in Jacksonville, you had the pleasure of replacing the woman who was arguably the worst public prosecutor in the United States. Your current state attorney is one who is reform-minded, and we've had the chance to talk with her about things like what is the process by which prosecutors are charging children as young as 13 as adults for particular nonviolent crimes? And it's a subject called direct file. We've talked with them and moved forward on the policies governing how juveniles can get their records expunged when they turn 18 or 21 and have a better shot of going to college or going to trade school or things along those lines. On the adult side, we have focused a lot of our attention on sentencing reform. The idea that Florida has very archaic mandatory minimums for nonviolent drug offenses. They've done a little bit of progress on those, but we still are treating drug abusers as if they are traffickers in the drug sentencing laws. And so that has a very disparate impact across the state. We have been very successful in moving forward a pre-arrest diversion program. There was one for juveniles, or there has been one for juveniles for several years. A few years back, the state enabled the counties to enact one for adults as well. And there was a model in Leon County, which is where Tallahassee is, that they were able to use to serve as the model for that. A couple of other things are in examining the use of driver's license suspension for inability to pay fines and fees, things like that, where you have folks that are unable to make a particular payment. They get their driver's license suspended, and surprise, they lose their job because they can't get to work, which further makes it more difficult for them to pay the fines and fees. Logic sometimes doesn't make a bit of sense. And then we get to pretrial detention. We prescribe to the idea that a pretrial risk assessment tool that's scientifically minded, that treats individuals in their situations the way that we would want, our own family to be treated, is one that can make strides. And while we may kind of differ a little bit on the total elimination of cash bail versus kind of a supplement or something along those lines, I think moving the conversation ahead and having folks come together and talk about what are the alternatives is absolutely the best route forward. As was mentioned by Vincent, I mean, we're talking about millions and millions of dollars in lost wages, and the ability of families to stay together, and the idea that those dollars are kind of wasted when a person is presumed innocent is something that we feel very strongly for. So with that, I'll turn it back over to the host and look forward to Q&A.
Thanks, Sal. I kind of completely agree with you. The fact that the net benefit of bail reform is going to be worth it due to the lost social costs, like you said, of employment, the long-term costs, and going that route. What would you have to say to the people who bring up certain things like causing or trying to institute reform would just cost too much money, or eliminating cash bail might put crime victims in danger? Or what would you also have to say to people who miss, if you eliminate cash bail, then you won't have anybody showing up for court? Now, these are just some of the common things that are brought to anyone's mind when you bring up the fact that you want to eliminate cash bail. And, you know, if they know what it's for, how are they going to show up to court? What if they're violent offenders? How is this going to affect crime in my community?
Sure.
These are great, legitimate concerns. And if anybody in the panel wanted to weigh in on any one of these questions, because I think they can also lead us into what Miss Ruth Ann Hepler can give a lot of insight into, as well as are they coming back to court, you know, from the front line. So if anyone wants to weigh in on any of those myths about bail reform, please feel free.
And I can just speak real quickly to the idea that this is why we support the idea of a very narrowly tailored, very robust pretrial risk assessment. It's something that researchers from across the country are working on. They're testing in a number of different jurisdictions, and they're seeing some very good results. And so too often an individual is able to avoid pretrial detention because they have money or because they have wealth versus whether or not they are a risk to flight or to not return. And so we see that as an economically disparate argument. And so the pretrial risk assessment for us is one of those ways that, as kind of a nerd, I look at it and say, well, maybe we can put some science and some you know, some significance, some statistical validity to the process.
Kind of on that note, how would you feel about actuarial algorithms being involved in this process of the pretrial risk assessment? I know that's been instituted in some areas in some municipalities.
Yeah, I mean, there's an element to that, and kind of the devil's in the details on some of the things. But one of the things that we've actually promoted very recently in some of our articles and writings, and it's kind of off topic, but it'll bring me back, is a replacement of qualified immunity with an actuarial program to almost charge jurisdictions like malpractice insurance for their in lieu of qualified immunity for police officers. So they are incentivized to have better officers who do not do very bad things. And if they keep them on the force, or if they have bad apples that are consistently driving up premiums, it's a market solution for a problem that society is currently looking to address. And so, you know, I, for one, am a free market guy. So anytime we can inject market forces into something like that, I like to look at that.
Excellent. Did anybody have anything else to add on some of those myths?
You know, Washington, D.C. hasn't had money bail for quite some time. And what we've been able to see is that when you compare rates of like failure to appear rates or rates of being rearrested on a particular offense, what we see is actually people are coming to court at same rates, if not higher, when money is used versus when it's not. And so this idea that money is required to get people to show up to court that's not represented in the jurisdictions that we've seen the elimination of financial conditions of release. And similarly, in terms of rearrest rates, which I know is a concern as well when we talk about bail reform, we're not seeing any type of increase in rearrest rates in jurisdictions that aren't using financial conditions to release people. There is a lot of conversation about risk assessment tools in the conversation of bail reform. And I do just want to put up a flag of caution for us to consider, you know, how these algorithms are generated, the data that is utilized to create the algorithms and the equations to generate particular risk scores. If we have a global understanding of some of the biases that are baked into our criminal legal system, when that data is put into that algorithm, that bias can get replicated by the algorithm. So we want to be cautious about how we're using risk assessment tools. They can certainly be one of the tools that judges can use to consider. Definitely not the sole tool, not the only tool. But I do appreciate Sal bringing that up, because a lot of people are having conversations about these risk assessment tools. And in that same conversation, we want to be mindful of some of the biases that might be inherent within them.
100% agree with you there.
Sal, you'd mentioned Texas. I'm actually from Houston in Harris County, and Harris County is one of the places which had an abhorrent county jail system and a lot of bad stuff going on there. It's had the third largest jail system in the world, just to let you guys know. It reformed its pretrial system as part of a consent decree. So it virtually eliminated the use of money bail for misdemeanor charges. How do you guys feel about separating the charges versus misdemeanors, or looking at crimes versus misdemeanors and felonies, and what aspect does that play to dangerousness? Maybe anybody could kind of speak to this. In Houston, that program has been a success. So just like Mr. Snowden had mentioned that they had done in DC, experts estimate that the reforms would result in the pretrial release of 90 to 95% of misdemeanor defendants. And that does sound like a statistic that would take a chunk out of the jail population and also save a lot of money.
Yeah, one of the things that we point out fairly frequently is that the only thing you do when you put someone who has been charged with a low-level offense into a jail system or a prison system is you have the tendency to create a better criminal, or to create a criminal out of someone who wasn't a criminal. And so to the extent that we are moving individuals who, again, are presumed innocent into a program that is not jail-based, and we can show, as Texas and other states have, that you can do that without spiking your crime rates or your incident rates, we should be pursuing those ends by whatever means we can.
I would add, and I would phrase it a little differently. I wouldn't say that pretrial detention is making more criminals, or I would think about pretrial detention as making people more vulnerable. Like in New Orleans, I didn't share this. I was a public defender for 5 years before coming to Vera. I remember talking to people on the first day that they were arrested, and the second day they were arrested, they kept talking about they had to get out to keep that job. They had to get out to continue to provide for their family. But then when they would, if some people would plead guilty on day 75, they've lost that job. They've lost custody of their kids. They've lost their housing. And so now they're so much more vulnerable. And as they respond to the strains of society because of this pretrial detention, we're not promoting them. We're not doing a needs assessment about how to actually set that person up for success.
And you raise a great point that is something we haven't touched on yet, and that is when someone is in pretrial detention for an extended period of time, they are far more likely to take a plea deal even if they haven't committed the crime to begin with. Why? Because they recognize the need that they've got to get out, they've got to get back to their family, they do not want to be. So a prosecutor has the kind of upper hand in terms of leverage, getting them to plead just to either make it go away or get out on time served. And now you've tagged that person with a record, which makes it that much harder for them to become productive and whatnot. So that's another element of it that I think is, when we talk about collateral consequences, kind of goes into that equation.
Yeah, that's absolutely an element that we haven't actually touched upon, and that's that stain that can affect, wealth-based, and it's just based on whether you have the ability to get out or not, and that's going to target low-income communities and have long-lasting repercussion effects. That's completely it. It's what do I have to do to get out of here to continue my life? Because everything comes at a standstill when you're locked up, and you can't do anything. And if that drains your entire family, even if you do get out, you've got to start from scratch, and that's hard for a lot of people. Definitely. So we can move on. Let's talk about Jacksonville and Duval County here in Florida. Miss Ruth Ann Hepler, are you almost set there?
I am.
Great.
Just a little bit by way of background, I have been a criminal defense lawyer for 29 years now, and I did what I call 2 tours of duty at the public defender's office here in Jacksonville for a total of about 13 years. I am back in private practice now, doing criminal defense, and I went out to JU to do the Masters in Public Policy program in 2016, I think. And so when it came time to do the capstone project, I was very interested in this bail issue. And I saw it as my opportunity to actually look at what goes on in Jacksonville from a, statistical, actually look at the numbers kind of perspective, because my gut told me from standing in the courtroom every day for so many years that the people who were released on their own recognizance, what we call ROR, came back as often or more often, it seemed to me, from an anecdotal perspective, than the people who had a bail bondsman. And so I said, let me, look at this and see what the actual facts are. So I did my capstone project by looking at all of the misdemeanor cases that were processed in Jacksonville in 2016. There were 15,177 cases. And again, as we've talked about, there's 2 primary issues with bail. One of them is the person gonna come back to court? That's the primary issue. And obviously the other issue is, are they a danger to the community if they're out? So I chose, for a variety of reasons, to focus on misdemeanors and to focus on the failure to appear aspect of it rather than the danger to the community or the reoffend aspect of it. So what I did was I looked at all the cases and ran the numbers on how many people came back to court and how many people didn't, and whether they posted bond or were released on their own recognizance. And what I found was that, well, first of all, of all the people charged with misdemeanors, 13% were ROR'd, and 78% had to post or were given the opportunity. We'll say they didn't all post bond, but were given the opportunity to post bond. And the failure to appear rate for those who were ROR'd without posting any money was 2.39%. The failure to appear rate for those who posted bond through a bail bondsman was 8%. So I was very happy that my anecdotal evidence turned out to be actually statistically true, that my gut and my experience in the courtroom was actually borne out. What I like to say now is that in Florida, at least, we don't need to change the law. We need the judges to follow the law. We have the law. The law says there's a presumption in favor of non-monetary release, which means the first option the judge is supposed to look at is, can I ROR this person? In reality, that's flipped. In reality, most of the time, the last thing the judge looks at is, could I possibly ROR this person? Which is why, we end up where we are. As part of my research, I found that in 2016, we had an average of 232 inmates per day in the Duval County Jail pending trial on misdemeanors. The jail was over capacity in 9 of the 12 months in 2016. So that kind of gives you a picture of how many people in Jacksonville are being held pre-trial on misdemeanors because they can't afford to make bond. In Florida, I know Will talked about in New Orleans, the premium is 12%. In Florida, it's 10%. The bondsman charges 10% of the bond. And I didn't even know this until I started doing my research for this project. It's actually a crime in Florida. It's a first-degree misdemeanor to bond, for a bail bondsman to bond someone out without charging that 10% fee. So it's definitely a system. And Florida actually gives bail bondsmen an amazing, to me, shocking amount of chances to recoup the bond if the person doesn't show up, which my personal theory is that's why they don't show up, because the bondsman just comes back to court and says, oh, judge, I didn't get him, but, give me my money back anyway. And they do. So the whole idea of that being an incentive is really misplaced. The alternatives that I talked about in my project to the bail, there's a lot of alternatives, and obviously this is a huge topic that I could talk about all day and we could talk about all week. So I'm giving a highlight of a highlight here, but some of the alternatives are using a GPS ankle monitor, or using a SCRAM, which is an alcohol monitor. It's like an ankle monitor that also monitors your alcohol use. And those sound like great ideas, but what I've found in the last few years, I think the judges in Jacksonville have actually gotten better, especially on misdemeanors, about the bonds. We've got a long way to go, but I feel like, again, just anecdotally, that it has gotten better, that they're starting to realize that they don't need to give everybody a huge bond. But on the flip side, what they're starting to do now is give everybody an ankle monitor or a SCRAM, which costs even more than the bond. So we've kind of, gone 2 steps forward and 1 step back in this whole process in Jacksonville. And in addition, the GPS, in addition to costing a lot of money, you have to pay for it every week. You have to go down and get it monitored every week, and it restricts where you can go, and it interferes with people's jobs, and there's all kinds of other things. So it sounds really great, but in practice, usually not so great. We have pretrial services here in Jacksonville. We've had it for quite a while now. And I feel like it's very underutilized by the judges. Pretrial services is run by the sheriff's office, and you go in every week or whatever it is, and check in, and they're supposed to keep tabs on you and make sure that you're coming back to court and doing what you're supposed to do. And I feel like that's very underutilized by the judges. And one of the values of it is that it's free. It doesn't cost people any money. And they can even do random alcohol testing for free. So I think that's something that we should really be looking more towards in Jacksonville. One of the things I recommended as something that we should do in Jacksonville, part of my research for the project was, there have been some experiments, and our other panelists probably know about this. There have been some experiments in other places. One of them was Colorado, where they implemented a simple phone call or text message system to remind people about their court dates. And it was phenomenally successful in making sure people came back to court. And what I always say is most of these people, when they don't come back to court, they're not coming back to court because they're trying to run. They're just disorganized. They need a calendar, And so this program of having an automatic, it's 2020, you can have an automatic system that sends them a text message to their cell phone saying, don't forget your court date's next Tuesday. It's so cheap and it's incredibly effective. So I think that's something that Jacksonville should look into and do the cost benefit analysis. And then the risk assessment tools, which, as we've talked about, there's a lot of controversy about that, but personally, I think it's a good idea. So one of the things that stood out to me in my analysis of the numbers in Jacksonville was that only 40% of the people who got a bond could afford to bond out. So 60% of the people, misdemeanors, the judge said, okay, I'm going to give you a bond. They sat in jail because, okay, great, you gave me a bond, but I can't afford it. Even though all they had to do is pay 10% of that to the bondsman. So the system definitely does penalize the poor. I found that keeping all those people in jail in Jacksonville costs more than $5 million a year, which is a very conservative estimate because I had to use the numbers that the sheriff's office provided me, which were not very up to date. So that's a very conservative estimate. We're spending millions of dollars just in Jacksonville to keep people in the jail on misdemeanor pretrial when we don't need to. So again, since I found that the failure to appear rate is actually higher for those who post bond through a bondsman, the conventional wisdom obviously is not true, that the bondsman gets people to come back to court. So one of my policy recommendations for Jacksonville was that we should do a systematic periodic review of our system. Somebody should be keeping track of these numbers so that every year or every 6 months or what have you, they report to the chief judge and say, this is how many people bonded out, and this is how many people came back, and this is how many people failed to appear. But nobody knows what the numbers are because nobody's tracking it. I think we should do the pilot program for the automated text messages. I think we should do a thorough analysis in Jacksonville of the cost of keeping people in jail pretrial. And again, one of the things that we need to do is change the culture of our judiciary so that the judges are actually following the law that we have, which says your first consideration should be releasing someone with no bond. And it really is, I think, a culture change among the judges. And it's slowly starting to change. But we don't need a bunch of changes in the law. We got the law. We just need judges who follow the law. So that's my my short synopsis of my view of what happens in Jacksonville on the ground.
Awesome. Thank you so much, Ruth Ann. So you mentioned metrics, and before we had gotten on to this group meeting, I had brought up the fact that Georgia had made some legislation that forced them to keep metrics that would let us know if the jail populations, if what they were doing was working. And when they went in and looked at those metrics, it looked like although they had the statutory authority, to have a presumption against cash bail or in favor of release on own reconnaissance, that the courts were still not complying. So in your opinion, how do we tackle compliance with judges? Is that by making awareness, or where do we go from on that end?
Well, I think that that's a great idea that they did in Georgia to have, a statute that requires somebody to keep the statistics, because nobody's going to keep the statistics unless somebody's forced to do it. And when I did this project and went and talked to the clerk's office, their computer systems aren't really even set up to track this information because nobody's ever asked them for it before. So I think a statute like that is good. But as you pointed out, a statute doesn't make judges actually follow the law. I think it's culture, and I think it's education. And I think when the judges realize that, the actual evidence shows that bail bondsmen are not bringing people back to court, then that's how we start to change the culture. But it's very difficult. But education, I think, is really key.
Excellent. So there's still a place for research in this area, and a place to, provide data and get presentation and get that information out there to decision makers, either legislatures or judges, about the repercussions of continuing, as you called it, that culture or that tradition of just automatically assigning bail bonds in these kind of exorbitant amounts for some folks. So also, let's see, one other thing you brought up that some critics might speak to is the pretrial services. And I know Sal had brought this up too. If we enlarge pretrial services, if we make that big enough, make this bureaucracy big enough to handle the that flow of pretrial detention to try and stymie that, is that going to have a significant cost on taxpayers? Is that going to require more infrastructure besides what's already in place as far as the process?
Well, I guess I should have qualified what I said. A lot of people honestly don't need pretrial services. You just ROR them, you tell them to come back to court, maybe you send them an automatic text message to remind them of their court date, and they're totally fine. Pretrial services is really for people who have some risk factors. Maybe they have an alcohol issue or what have you. It's to give a little extra special attention to those people who might need help, all the collateral social services and so forth. So I don't think it would cost a lot of money. I think I know we have the program now, and it's just underutilized. I think the judges again need to be educated on who needs to go to pretrial services and who doesn't. And we also, have a thing in Jacksonville where the idea of pretrial services when we first implemented it in Jacksonville was you can ROR the person and let pretrial services keep tabs on them. And then it became, well, I'm going to give you a $5,000 bond and I'm going to send you to pretrial services, which defeats the whole point, So again, it's education about what's really necessary, I think.
I'm sorry.
We've a couple of things. So, research tells us, and Ruth Ann hit this on the head. One of the main reasons people aren't showing up to court is not because they're trying to evade prosecution, it's because they either forgot, they don't have transportation, or they don't have childcare. And
Right.
so one of the programs we're working on in New Orleans is a community supported release program that does the text message notifications that Ruth Ann was talking about. We're looking at creating some type of a voucher system where if you show up to the New Orleans Regional Transit Authority, like you hop on the bus with a subpoena for court that day, that gets you a ride to court and that gets you a ride home. We're also talking about creating a voucher system either with Lyft or Uber or some type of ride share app to help get people to court. And then also thinking about how do we utilize vouchers that help provide childcare for people that aren't able to bring their kids to court. And then in terms of like the money aspect, in the report Paid in Full, we were able to analyze that the city of New Orleans in 2017 spent $6.4 million detaining people in jail and only collected $4.5 million from the revenue of the bail fines and fees. And so we're actually spending more money keeping people in jail than we are profiting from it. So there's a lot of conversations to be had about how we can change our approach to the conversation about pretrial detention, not only from the perspective of the collateral consequences that may come from that unnecessary pretrial detention, but also from a financial savings element. Are we actually, is this actually a worthy investment for what we're trying to promote?
And one quick point on Ruth Ann's thing about text messages. So in Palm Beach County, just kind of a separate program, the clerk of court implemented a text message program to work with folks on their fines and fees. So it would give them a kind of reminder. It would tell them where kind of an alternative payment for, get in touch with us if you're having issues. They had their collections go up exponentially almost immediately. And so the proof is there just from another kind of program. And so they've been kind of marketing it, so to speak, with other clerks of court around the state to try and kind of boost the collection rates and work with folks on payment plans. And so there's some evidence to show that, exactly to your point, people aren't necessarily avoiding either a fine and fee payment or a date because they're looking to avoid it. It's one of the elements that Will had mentioned.
That's fabulous.
Mm-hmm.
I think that really goes to burning the candle at both ends, marketing solutions that work, that are proven, and as well as, helping, the social aspect, which is basically, we're not dealing with criminals for the most part, it's, people who just can't get there for one reason or another, or they forgot, or, these are like common everyday problems that we encounter all the time. But in the context of making it to, a bail hearing or being able to perform bail, they can have devastating consequences. Kind of bringing up on that note, here's something pretty interesting. I was contacted, I think about a month ago when I started getting into this project and this research from a company called Corasoft. I'm not sure if any of y'all are aware of this company, but they're looking into alternatives to the scram and alternatives to the monitoring, and it's all kind of cell phone based. And it's app based, where it's just based around the cell phone, where they get the alerts, they get the messages. They also have different programs where they can put into a fund for rides and different things of that nature. But it's technology based. What do you guys have to think about any kind of alternatives that are either web based or phone based and going that route?
Oh, I think it's fabulous. I mean, it's very cost effective and everybody has a cell phone now. And, you do what works and what doesn't cost a lot of money. It's just common sense,
I thought it was also a pretty novel idea. The one thing they did bring up was that the person had to use their proprietary phone. So, but something worth looking into, something that may come up in the future. They said that they were in the process of being kind of beta tested in a few counties in Florida already. So maybe they'll come up with some positive results there. So it's about 7 o'clock right now. If we have any chat questions or not, I'm sure I still have some more questions, but we can take some questions from the audience, or if any of the speakers want to bring up any of the points from the other speakers concerning some of the stuff that was brought up today.
Yeah, I had a quick comment just on kind of laying out Vera's approach to bail reform. So when we're looking at, different policy changes that are being proposed, there's essentially four things that we're regularly looking at. Does the reform, first, does the reform eliminate money or greatly reduce the role of money in terms of pretrial detention? Second, does it decarcerate, meaning does it reduce our pretrial detention in our jails? Third, does it end or dramatically reduce the racial disparities that we know exist in our criminal legal system and pretrial detention? And then fourth, does it do so in a way that does not compromise public safety? And so as we are seeing these different reforms being talked about and explored, around the country around bail reform, I just wanted to share those are kind of the four tenets that we often look at to see if the bail reform is actually consistent with what we know to be best practices.
Those are excellent tenets. Speaking to the money issue, maybe Ruth Ann can help us answer this. In Florida, there's the Supreme Court of Florida has held up the presumption for cash bail bonds.
I'm not sure what you mean exactly.
The Supreme Court in Florida, have they held up the presumption for cash bail bonds, saying that instead of the presumption of ROR, if a judge just automatically signs the cash bail bond, that's considered not violative of any constitutional rights, despite some challenges to the bail system recently in Mentor and I believe in Pew.
Yeah, the Mentor case ended up getting dismissed and has not been refiled, so that never really got a hearing. But yeah, I mean, cash bail is legal in Florida. There's no question about that. But the law states that there's a presumption in favor of non-monetary release. So it's not, if the judge gives you a bond, there's nothing illegal about that. But the rule, then the statutes say the presumption is supposed to be in favor of non-monetary release, and that each person is supposed to get an individualized review of their situation to determine, what are their ties to the community? Can they afford it? What's the likelihood they're going to come back? When in reality, first appearance is a cattle call, and the judge is more interested in how quick can I get out of here than let me look at your individual situation. So yeah, it's legal. Bail bondsmen are legal here in Florida. But that doesn't mean anybody has to give you a bond that you have to use a bail bondsman for,
I had a question for Ruth Ann on that particular thing, because you mentioned that there's an education process for judges that to kind of educate them a little bit on the fact that presumption exists. Is there also an education that can be brought to bear for defense attorneys? Are not enough of them making that claim before a judge that, judge in Florida, this is the case, and you're supposed to presume?
I think criminal defense attorneys, we spend half our time making these arguments and they go nowhere.
Okay.
So okay. Yeah, no, it really is a culture. I mean, I've been doing this for, like I said, 29 years, and it's a culture of this is how we've always done it. And it's a like Vince said, it's sort of an urban legend that even judges have in their mind of if you make them post a bond and go to a bail bondsman, the bail bondsman is going to make sure they come back to court. But the reality, as we all know, that's not true. It doesn't actually work like that. And so I think we have to educate them to see the actual evidence and see that it doesn't actually work. That all we're really doing is lying in the pockets of bail bondsmen. And we're not getting people back to court. We're not ensuring the safety of the community.
Kind of speaking on that note, maybe shifting gears just a little bit. Another aspect of this discussion that we couldn't have is the underwriters for the bail industry, the bail bond system itself, and kind of their influence on the legislators. And that respect, I know that there is a bail bond lobby. The underwriters for the insurance of the bail industry are pretty powerful. And I believe, correct me if I'm wrong, I think it was Senator Cory Booker had introduced some legislation to kind of hit the root of the cost problem, which is these industries are making a lot of money off of bail, and it's a virtually risk-free investment. Like you had mentioned before, the bail bondsman, if they don't show up, they can maybe ask the judge for a waiver, but 98% of the time they are going to show up, and that's a lot of money being drained out of the communities. And it's also, you know, a very powerful lobby they have a standpoint and they have a view. Even going online today, just looking at some kind of bail reform, I saw several articles written by insurance underwriters, and they kind of had the flavor of a journalistic piece, but they were a kind of a ad piece written by the insurance underwriters or a bond company even. So on that kind of front, what can we do with that as far as making people aware that it's an industry, it's making money off of, you know, basically a lot of negative effects that it's causing in the community. So maybe that's another aspect that we can touch upon if anyone wants to talk about that.
It's a huge lobby, as you said. I mean, they spend an ungodly amount of money lobbying legislatures. And I think the answer is, I mean, personally, I would be thrilled if we outlawed bail bonds, commercial bail bonds in Florida. I'm not sure that would ever actually happen, at least in my lifetime, but it would be great if we did. There are some states that have outlawed commercial bail bonds.
So we do have a question from the live feed on Facebook. And the question is, what constitutes excessive bail? And as I ponder that question in the perspective that our speakers have given, can one go to the heart of the original policies behind bail, going way back to English courts? And can you look back there and look at the fact that the power gap is so huge between the person that's very, very poor and yet has this system applying a bail against them? It's like the widow's mite in the Bible. Mm-hmm. For the widow, it was such a huge piece of money, but the other people there, it didn't matter. So it's the same thing here. Does this actually constitute excessive bail? Has anyone done any research on that? So that's the question.
Excessive should be no more than necessary to assure appearance, but also when you go into that, then there's a lot of leeway there, and accessibility has been found by the courts to have nothing to do with affordability, which they're two separate determinations, so to speak.
Any thoughts on that, Ruth Ann?
Well, I mean, what's excessive bail in any particular case depends on that particular case. So, mm-hmm. You know, it's a concept. We're not supposed to have excessive bail, but, you know, basically if somebody's charged with trespass and the bond is $1,000, I would say that's excessive bail, but the Florida Supreme Court's probably not going to agree with me. So, you know.
And I would, my framework would be excessive bail doesn't depend on the charge, it depends on the individual. And I think what we see is an amount often gets associated with the charge. But if you don't have two nickels to rub together, you could set the bail at $100 or at $10,000. It might as well be $1 million if the person doesn't have access to that wealth to pay it in the first place. And so in New Orleans in 2019, there were two federal lawsuits that ruled on the constitutionality of bail in New Orleans. And essentially what it found was the way that we were using money bail was unconstitutional for two reasons. First, it was unconstitutional because the magistrate judge was not doing an ability to pay determination, which is just required. And second, there was a financial conflict of interest where a judge, you know, when they set a bail amount, there's a 3% court fee and 1.8% goes to the court. And so as a financial conflict of interest, the federal court says you cannot be the entity that decides the size of the pie, knowing that you're going to get a slice of the pie. But I just bring that up because we really should be focusing on ability to pay. But the problem is we have a court of public opinion where if somebody is charged with murder, a judge is going to set $1 million bail on that person because they actually want to detain that person, right? Bail really is supposed to be indication that a judge wants that person to be released, but at a particular amount, because they believe by putting up that particular amount, you're going to assure that person comes back to court and they're not going to reoffend or get rearrested. But as I said earlier, now that we've had the commercialization of money bail, that kind of insurance element, that kind of collateral element that money used to pay is no longer in existence. So I think we really have to focus on measuring excessiveness in terms of bail based on an individual person's ability to pay.
And in Florida, that the judge is supposed to consider that, but in reality, that rarely happens.
Yeah, I would echo Will's point on that as well, that if you're basing it on a charge and you're setting a $1 million bail for a murder or $1 million bond for a murder charge, and you've got two people accused of different murders, and one does not have that, anywhere close to that, and one of them is a multi-millionaire and is able to post it, you've effectively created a disparate outcome that has absolutely nothing to do with the presumption of innocence of those two individuals to that particular charge. So, I'm with Will on that, especially the first part of what he said there.
Yeah, absolutely. And the culture in Jacksonville, at least, which is the only place I've ever practiced law, the culture has always been, for example, a DUI gets a $5,000 bond. That's just how you do it. DUI, $5,000 bond. You know what I mean? It's a culture of, like you said, a particular charge equates with a certain bond. A trespass is $2,500. You know what I mean? And so it's the not only not following the law, but the mindset of changing that.
Guys, we do have some audience questions I wanted to hit on before we ran out of time. A lot of them you guys have hit on with your discussion, for sure. But the first one is for Ms. Hepler, and that's, this could be a general question, honestly, too. A lot of states have passed legislation that basically says you have to take into consideration when you're giving bail, you have to take into consideration their standpoint or their financial situation. Is that realistic? And is it enforceable?
Well, like I said, we already have that. That's part of our law. But the reality is most of the time that's not a serious consideration. And so, what the law says and what actually happens in court oftentimes are two different things.
Do you think there's a way to enforce it, an actual legitimate way to do so?
No, not really. I mean, it's just like I keep saying, it's a culture change,
And I would add that very question was part of the lawsuit here in New Orleans. The case is Caliste versus City of New Orleans, specifically looking at, the judge just was not taking into consideration the person's ability to pay. And the transcript proved that. And so it's enforceable in terms of, like, if a judge is just making a record where they're not taking into consideration the person's ability to pay, you can, file an appeal. But then what happens is the judge will say things on the record to make it appear like they're taking that into consideration, but the amount is the exact same. So to the person's question, Michelle, I think it is, and just to echo what Ruth Ann was saying, it's very hard to enforce because on its face, a judge can say, I'm taking into consideration X, Y, and Z, but they may not actually be taking that into consideration.
And who can afford to appeal? Nobody. It costs money to appeal, right?
Awesome. And then the second, I'm just going to direct these at the entire panel just to make things nice and easy. What do you guys believe or what have statistics shown is the coexistence between bail and privatized prisons?
I'm not sure there's a correlation in my mind because prison is where people go who are sentenced. We're talking about people who are pretrial. So like in Jacksonville, the people who are pretrial who can't make bail are held in the Duval County Jail. They're not going to a private prison. So I think we're maybe mixing apples and oranges there.
I don't think there's much of a connection, but I will underscore a point that Sal had shared in his discussion. People that are fighting their case from the street are people that versus people that are fighting, case from jail have a different position of power where, and the DA knows that, a DA is going to know that somebody's been in jail for 6 months. They're going to be more likely to take this plea deal than somebody who is fighting their case from the street and feels like they have more of an ability to actually go to trial. So I don't think there's a connection between the money bail system and privatized prisons, but I do think there's a connection or correlation between the person's position in fighting their case and the outcome of the case, whether that is a custodial sentence, like being sent to prison for a term of years, or actually maybe getting probation or something like that.
Guess I'll keep it moving. And I just said I was going to direct this at the whole panel, and now I'm negating that by directing this towards Mr. Nuzzo, so I apologize. As we try to affect change in our communities, what are some bipartisan selling points to highlight and garner support, just specifically since you've kind of shown yourself as a more conservative organization?
I would say that the concept is to speak to your audiences in the languages that's going to be the most persuasive for them. So like I said when I gave my initial presentation, when I speak to groups around the state who are kind of members of JMI, folks who follow us regularly, who kind of digest our research, I'm speaking to them from a perspective of, here's how we can better steward tax dollars and protect the public in ways that you did not otherwise think were possible. And let me bring to you these arguments and this evidence and this policy idea. When the folks that we worked with from Southern Poverty Law Center spoke to their members, they spoke a different language or a different story or a different angle. But in the end, the policy solution was exactly the same. It's just a question of how do you bring your audience along? And I would stress that for all of the problems, and no denying that the last 4 years were what they were, one of the single biggest wins of the last 4 years at the federal level was the First Step Act. And it was a policy win because conservatives and progressives came together in the Congress and did what they were supposed to do for a change. And so while we may not necessarily agree with all of the tenets of the specific elements of the bill and what it did or what it didn't do, or whether it went far enough, I think those two groups in the end, I mean, you had folks like Cory Booker and in the end, Chuck Grassley coming together to work on a policy goal where the goal was the same. They just spoke about it differently.
That's awesome. That's deep. Thank you. And then the last one that I'm going to ask is, do you think, you guys discussed how, it's essentially not enforceable because they're making their decisions. While you can make at face value, you can make it seem as though you're taking a financial standard into consideration, but realistically you're not. Do you think that has to do with any bias, not even primarily racist in terms of race, but even just low income bias of those on the street or the kind of crime? Do you think bias plays a big role in that? And that's to everybody.
Sorry, I missed the first part. Bias in outcomes of what? I'm sorry, I missed the first part.
Just judges deciding not to use the standard that they were dealt or the legislation in terms of taking into consideration one's financial standard.
So from my perspective as a public defender, I think I would be treated differently, and the person I was representing would be treated differently because I wasn't a private lawyer. For example, in our bail hearings are called first appearances, and the magistrate judge would always go, are there any private attorneys? Are there any assistant district attorneys? And then he would go, and then are there any public defenders? Like, we were always the third. We didn't have the privilege of private attorneys. And then just also thinking about the way a private attorney was able to advocate I don't know, and New Orleans just might be different, but the way that judges would treat the private attorney and translate that kind of privilege to the client they were representing was very, very apparent during those bail hearings. And when a private attorney would make representations about, this person, has a family, they have kids, yada, yada, it just felt like a judge would listen differently to the private attorney than when I would get up and make similar arguments about a person's family connections. My client wouldn't, that information wouldn't be received the same way.
And I completely agree with what Will said. And in reality, it's sad but true, but judges do use bail to coerce pleas out of people, which is something I think Sal touched on earlier, because basically the judge knows that if I set the bond high enough and this person can't get out, but by the next time we come back to court, he's going to plead and he's going to be off my calendar because he's not going to want to stay in jail. And so from that perspective, that that plays into it as well. And the judge also knows that if the person can afford a private attorney, they're probably going to be fighting their case and they are going to come back to court. But if they can say, oh, I know this guy's poor and he's not going to be able to afford this bond, then I'll give him this high bond. And then I know he's going to plead, It's just
I would only say my thought is I would think that it would be more class-based in terms of the presence of a bias than it would be race-based. But with that said, I believe the Orlando Sentinel and the Tampa Bay Times have both done investigative pieces over the last 5 years where they kind of put forth a lot of data that show that it was more race-based with an element of class-based in there. So I can't remember off the top of my head when those came out, but it was in the last 4 or 5 years that each of them have done some looks at kind of disparate treatments from the bench on particular defendants, whether it was class or base race.
That's the sad truth that I was anticipating hearing, but thank you for being open with us. Ms. Hepler, Mr. Nuzzo, and Mr. Snowden, thank you guys for answering those questions. I'm going to send it back to Vincent. That's it from the audience.
Yeah, actually, Sal, in some of my research that I've done in criminal justice reform and bail, some studies found the same thing, that there was a racial disparity component to that, but obviously, like any statistics, it may be a little hard to extricate out of the other things going on. So I think we've had a great meeting so far. I've actually learned a lot from all you guys. I'd like to thank everybody for showing up, first of all. Thank the Jacksonville Urban League for bringing everybody together and giving me this awesome externship opportunity to kind of just like meet people, do what I love, focus on criminal justice reform. And I guess I can close down the meeting here. Here in a little bit, I'd like to close it down with a Bob Marley quote. If you are a big tree, we are a small axe. So bringing all of our organizations together, no matter what we're doing, little ripples here and there, we're hacking it away. So we're making changes and it's making good efforts. So leave everybody with some good feels. And yeah, I'm bringing the meeting to the close. If you have any other closing words or anything else to say, Mr. Stone.
Yes, thank you. Thank you so much, Vince. Those were very helpful remarks all the way through. I really appreciate your perspective. And just want to recognize the other interns that are on. We have Kyle Basinger in the background doing a lot of work. His focus is on access to dental care for underserved populations. We also have Camille Wheel Thomas, who is also working on criminal justice reform and was in a couple of our previous town halls. Those are both students at Florida Coastal School of Law. We also have Teresa Rizzo Saunders, who is working in the oral access health field as well. We also have, who's not on with us today, but Jocelyn Mora, who's actually at FSU and is working in our oral access to health area. And I think I've covered everyone.
Hello, Dennis. Dennis.
Yes, Richard.
Hi, Richard again. Listen, I just want to thank Ruth and Will, for that information. It was right on. It was very, very professional. I learned a lot, and in our advocacy work, it certainly can help us, move the cheese. We've just got to chip away at barriers that are there that prevent our folk from having a decent quality of life. So thank you all for very much, and thank everyone for joining us.
Thank you, Richard. And I too want to thank our speakers, and particularly their willingness to handle a controversial issue, taking different sides. It's the kind of thing that we want to promote at the Urban League, and we think the world needs right now. So thank you very much for that. I had just one closing comment. We have a criminal public safety and crime prevention task force, a commission, and we also have a group within this city hall itself under the mayor's office with the same focus. And it seems to me that we've identified some low-hanging fruit here in terms of causes of crime that we ought to be looking at. Some very simple things that might be done through the judiciary. So hopefully we can bring that back to the commission and to the mayor's office and see if we can generate some interest in that. But with that, again, thanks everyone. Our next town hall in the criminal justice reform field is in December. I believe it's December 9th, and it's going to focus on